So we are living certainly in very exciting times. We are living in a time when all of us are increasingly finding ourselves in a much more digital world than ever before. And it is in this context and in background that today in Parliament, the government, Prime Minister Narendra Modi's government has introduced a bill called the Digital Personal Data Protection Bill. Now, many of you who are seeing the disruptions in Parliament and the shenanigans of the opposition may say, "What is this bill about? Why is this such a milestone, and what is so great about this bill?" And I thought I would spend some few minutes with you to explain to you why this is an important bill, why the journey so far in the evolution of this bill has been extremely interesting, and why the bill in a lot of ways will transform the lives and improve the rights of individuals who are today the digital nagriks in a way on the Indian internet. So first of all, clearly today India and all of us are seeing that increasingly we have to deal with many platforms, companies that we refer to in technical terms as data fiduciaries, as companies that deliver to us, to you and me, products and services online, that to deliver those products and services seek your data and use that data to deliver the product or service. Now, for many years, it has been known, and it is not any secret, that many platforms and many companies or many data fiduciaries have been collecting personal data of individual citizens, not just in India but all around the world, and have been exploiting that personal data for their own business models, algorithms, and many other ways. And frankly, this has been done without the awareness or the agreement of the person whose personal data it was. Now, this regime or this environment of big companies and small companies, technology companies, essentially creating business models by misusing and exploiting digital personal data of citizens is something that this bill uh, intends to address. And for that, let me take you back to 2017 when the Supreme Court ruled that the right to privacy is a fundamental right. And that happened because for many years during the UPA government, there was an almost total brazen disregard for the rights of citizens. And when they were building these huge databases during the UPA government, there was an absolute disregard to the right of an individual citizen to protect his or her data. And many people, including myself, I was then an MP, went to court, went to the Supreme Court, and argued that the government and indeed the private companies that deal with the personal data must have some obligations in terms of how they use the personal data of citizens. Now, fast forward to 2017, as I said, the Supreme Court had ruled in the public interest litigation for which even I was a petitioner, that privacy is a fundamental right, and therefore the Narendra Modi ji government swung into action to create a framework of a legislation that will then protect the citizens' rights, create an environment where the innovation ecosystem and startups can continue to operate with guardrails and move on in that type of a framework. Between 19 and 21, there was an attempt to create a legislative framework, the Digital Personal Data Protection Bill of 2018-19. So unfortunately, the formulation and the deliberations of that select committee created an extremely complex legislative framework that would have caused tremendous amount of compliance burden for our young startups and young entrepreneurs who were setting out to create startups and ventures in the digital economy. So back to the drawing board, our Honorable Prime Minister sent us and we worked hard for the last 1.5 years in creating an absolutely brand new framework of digital data protection, personal data protection legislation, which is globally competitive, very contemporary, very simple, very easy to understand, and most importantly, addresses the seemingly contradictory objectives that any world-class legislation should achieve, which is protecting the citizens' rights, creating a compliance friendly regime for startups and the digital economy's momentum and growth to continue, and to define the clearly emergent situations under which the government has access to the personal data of citizens during law and order, national security, and other emergent situations. These three seemingly contradictory objectives are met by this very modern, very simply drafted legislation that has been introduced into Parliament today. I think it will take a lot of the concerns and a lot of the misuse and exploitation that is done by many of these platforms, puts a break on that once and for all. This is certainly a legislation that will create a deep, lasting behavioral change and creates punitive consequences, high penalty punitive consequences for any or all platforms that misuse or exploit the personal data of any Indian citizen. I don't want to get into too much of the complexity, excepting to lay out some of the principles that have gone into building this legislation. These are certainly of interest to all those who are in the digital economy, as an entrepreneur, as a startup, as a user, as a citizen, as a government official who delivers and operates digital public infrastructure. The first principle is that the collection and usage of personal data by organization must be done in a manner that is compliant with this law. That means nobody can collect data today that is without the consent of the citizen whose data is being asked for. Second is what we refer to as purpose and storage limitation, which is that the data that is collected can only be used for the purpose for which it is collected. That means no platform can ask you for extraneous information, extraneous personal data that is not relevant to the service or product that it will be delivering to you as a customer. The storage limitation aspect of this second principle is that no platform can store the data for beyond the duration that it is required to store for delivery of a product or service. So purpose limitation and storage limitation are, in a sense, the cornerstones of the obligations that are cast on the companies that deal with collecting your data and delivering in turn some product or service to you as a consumer. The third principle is data minimization, which is that they can only, and I say this, it is almost a repeat of what I said in the second principle, but they can only collect the data that is absolutely minimum required data for the delivery of the product and service. That they cannot ask for data and use it for anything other than the purpose. They cannot ask for data that is not needed for the purpose, and they cannot keep the data for the duration beyond which the purpose that it is sought to deliver, the platform is sought to deliver. The fourth principle is data protection and accountability, that there are obligations cast on the platform to store the data even for the minimum period that it is storing it, even for the minimum purpose that it is using it, but store the data during the duration that it has it, without any breach, without any leakage, without any misuse and exploitation. And any breach of this obligation will in turn result in high punitive financial penalties that will be levied on the platform based on each user whose right is breached. The fifth principle is that the data will be stored in an accurate manner. That is, I am the platform and you are the citizen. If I collect your data and I store it, I have to also store it in a manner where the data is not altered, data is not modified by anybody, and therefore it is not then used and processed in an erroneous manner. So the personal data collected has to be stored in an accurate, error-free manner by the company that is actually collecting the data. And the sixth principle is absolutely mandatory reporting of breaches. No platform that collects the data and then finds that the data has been breached either willfully or unwittingly by its employees or by a breach of its cyber systems, can keep quiet about it and not report it, because that itself will be a breach of the law, and there is a mandatory reporting of breaches that is also an obligation cast on the company that deals with your personal data. All in all, this is a bill that has built in, like I said, the very strong principles of protecting the citizen, protecting and safeguarding the citizen's right to having his or her personal data being protected and not being breached by anybody, his or her data privacy not being breached. And on the other hand, making it simple enough compliance wise, not to create a burden of compliance on companies that are operating in the internet space, in the data economy space, startups that are innovating in the other fast exciting areas of AI and so many different segments that deal with data and deal with consumers on the internet. And of course, and the third, very important, in a very transparent, very clear manner, the government's right to access personal data in the event of a law and order, national security event or a national security challenge, and or a pandemic or an emergency situation has also been defined very clearly. The right to privacy is a fundamental right. It is not an absolute right, as you know, as most of our fundamental rights are. There are exceptions. The exceptions have been carved out, defined, and kept very clearly in the bill. The adjudication, the punitive consequences of a breach of this bill will be dealt by the Data Protection Board, which is a body designed specifically to adjudicate the financial penalties that will be levied on those who breach any or all of the obligations that are cast on them by this bill. So in very simple terms, if I as a citizen give you as a platform my data and you do not comply with the law, the Data Protection Board will take note of it and look at the problem or look at the nature of the breach, depending on the seriousness of the data, personal data, the sensitivity of the personal data, levy a penalty that could be as high as 250 crores per incident of breach reported, or even higher if there is a requirement for that. The bill in itself is a modern framework. It is an evolvable bill. There is the ability of the bill to create subordinate legislations and continuously evolve as we see challenges coming forth. And disruption is the normal in the technology space, and therefore this bill is a bill that will continue to evolve as we go down the route after this bill is legislated. But all in all, I want to share with you that all of us in the ministry and in the government who have worked very hard with all of these stakeholders, ranging from the citizens to the platforms to the startups to big enterprises, are very excited that we are able to bring to Parliament and to use this legislation to be a catalyst for not just the digital economy also, but for the growing envelope of digital rights for our digital nagriks on the internet. And I hope you take some time, understand it, read it, and be aware of this very, very significant milestone in the evolution of the global standard cyber law framework that our Prime Minister is building for our trillion-dollar digital economy, for all the startups and citizens who are stakeholders in the trillion-dollar digital economy, and the India Techade, that is the destination that we are all working together for. Thank you. Jai Hind.